Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to how the laws of war have been interpreted in the context of the war on terror. So let's get started. The primary objective of the laws of war or international humanitarian law is to protect certain persons who have not or who are no longer taking an active part in the hostilities, and to limit the methods and means of warfare that are employed by the warring parties. The laws of war are set forth in both treaty and customary law. The primary treaties are known as the 1949 Geneva Conventions. There are 4 Geneva Conventions. The first 3 are based on prior agreements that sought to regulate conduct during war, which are still technically part of the body of the laws of war, known as the Hague Regulations. The 4th Geneva Convention was adopted in the aftermath of World War II. The conventions list rules of the treatment of wounded and sick service members, prisoners of war, and, in the 4th Geneva Convention, civilians during the war. Generally speaking, individuals involved in international armed conflict can be divided into 2 separate categories. First, combatants, which includes regular armed forces and irregular armed forces working with the government. And 2, civilians. It is this distinction between combatants and civilians that is at the heart of IHL, whose primary goal is the protection of civilians to the greatest extent possible from the tragedies of war. The principle of distinction requires combatants to distinguish between combatants and civilians, and to take steps to ensure that civilians are protected to the greatest extent possible. Now, importantly, this definition carves out an exception as to when it is permissible to directly target civilians. According to both treaty and customary law, in an international conflict, citizens who directly participate in hostilities lose their protected status for the duration of the hostile act. Once they stop participating, they revert back to their civilian status. The laws of war also include rules regarding uses of certain means and methods of warfare that are designed to reduce unnecessary suffering. Under the principle of military necessity, the means that a party to a conflict is entitled to employ are limited to the degree and kind of force necessary to achieve a legitimate military purpose. Weapons that cause unnecessary suffering are considered illegal. Well, international law recognizes that despite its best efforts, civilian casualties are an unavoidable outcome of any military operation. No matter how carefully planned, as a result, it doesn't make all civilian losses illegal, but simply tries to regulate them. The concept is that civilian losses cannot be disproportionate to the direct and concrete military advantage anticipated from the result of the attack. Combatants have a duty to try to minimize civilian casualties and, if possible, to warn civilians about the impending attack. Now, whether or not an attack is disproportionate is dependent on the facts. It really is about trying to balance the military advantage being achieved against the potential loss of civilian life. This type of analysis may sound rather cold and calculated, but it is born out of a recognition that war will inevitably result in civilian casualties. The laws of war, therefore, do not make the incidental killing of civilians illegal. They simply try to minimize the damage that wars will inevitably do. In addition to protecting civilians during actual combat, the Geneva Conventions recognize the need to protect individuals after the war had concluded and one power was victorious. These are known as the laws of occupation. The laws are intended to strike a balance between the security interests of the occupier and the rights of the occupied population. Occupying countries are supposed to reestablish law and order quickly in the country, and they're not allowed to change the laws of the country unless absolutely necessary. The idea is to make sure that there is some form of legal continuity for the population after the conflict has ended. If a conflict is ended and all prior laws were deemed to be erased, chaos would likely result. Now, there is a safety outlet that provides that the laws must be enforced unless absolutely prevented. This clause was intended to allow states to excuse compliance with unjust laws, like Nazi laws, or to allow states leeway with respect to compliance if physical circumstances on the ground made it impossible. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.